Ma'am, please state your name.
My name is Stephanie Robertson.
And do you have a statement to read to the court today?
I do.
You may read it whenever you're ready.
My name is Stephanie Robertson, and I am the victim of a hit-and-run accident that has left a lasting impact on my life, physically, emotionally, and financially. Since the day of the crash, I have felt a deep sense of uncertainty and anxiety when getting behind the wheel. Driving, which is part of my daily routine to see the patients in the community as I work for hospice, now feels stressful. Being left in the car while you ran off like you did. I'm sorry. Made me fearful, and thinking of the day, that was the day that I was going to reunite with my two children in heaven. No one should ever have to feel that kind of terror or helplessness that you left me with that day. The incident has also left me with financial strain. Even with the insurance and the gap, some of the car was not fully paid for. Also having to replace the Kia and continue to work, the financial burden is still present. I hope the courts take into consideration that I am somewhat young and was able to sustain the multiple hits that you placed on my car that day. I can't help but wonder, what if this had happened to someone more physically vulnerable, like an elderly person? The outcome could have been much worse. The hit and run was not just an accident, it was an act that showed no regard for human life, safety, or responsibility. I'm asking the court to recognize the seriousness of what has happened, not just for me, but for the message it sends to others. Thank you guys so much for your time today.
Thank you, Ms. Robertson. That is it, Your Honor.
Thank you. Mr. Friels, come back to the stand, please. Joseph Matthew Friels, in docket number 2025 CR 240, upon your plea of no contest to count one, I find you guilty, sentence you to 11 months and 29 days in the county jail to serve day for day. You're ordered to pay a $350 fine at cost. You're ordered to undergo an alcohol and drug assessment and follow the treatment recommendations. You're also ordered to attend the victim impact panel and have an SR-22 for insurance. Your license will be lost for 1 year. We have the I don't believe you've gone over with him the DUI enhancement provisions. Is that correct?
I apologize.
Yeah, I have the I'm required by law to advise you of the following in open court. Any person who is convicted of a first offense driving under the influence shall be fined not less than $350, no more than $1,500, and shall be confined in the county jail or workhouse for not less than 48 hours, no more than 11 months and 29 days. Shall be prohibited from driving in Tennessee for 1 year, provided that if at the time of the offense the alcohol concentration in such person's blood or breath is 0.20% or more, the minimum jail sentence shall be 7 days instead of 48 hours. Any person who is convicted of a second offense shall be fined not less than $600, no more than $3,500, and shall be confined in the county jail or workhouse for not less than 45 days, no more than 11 months and 29 days. Shall be prohibited from driving in Tennessee for 2 years. Any person convicted of a third offense shall be fined not less than $1,100, no more than $10,000, shall be confined in the county jail or workhouse for not less than 120 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for not less than 6 years. Any person convicted of a fourth offense shall be guilty of a Class E felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class E felony, shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a fifth offense shall be guilty of a Class D felony and shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class D felony, shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a sixth or subsequent offense shall be guilty of a Class C felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child under 18 years of age, the person shall be fined $1,000 in addition to the fine for the DUI offense. and shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as a proximate result of the DUI offense, the person commits a Class D felony and shall be punished for vehicular assault as provided in TCA 39-13-106. If the child is killed as a proximate result of the DUI violation, the person commits a Class B felony and shall be punished for vehicular homicide involving intoxication as provided in TCA 39-13-213, subsection B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessments, conditions of probation, and monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring device, electronic monitoring without random alcohol or drug testing, global positioning monitoring system. In determining whether a conviction is a second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of the previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall also be considered in determining the number of prior offenses. For purposes of determining if a person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person convicted of DUI is a multiple offender, a prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI, as long as the person was convicted of the prior offense before committing the instant violation of DUI. A defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of a DUI offense. Unless a person convicted of violating TCA 5510-401 is determined to be indigent, the minimum applicable fine shall be a mandatory and shall not be subject to reduction or suspension. All fines are subject to be paid on the date sentence is imposed, unless the court makes an affirmative finding that the defendant lacks the present ability to pay. The court shall then order a date certain before which payment shall be made. Should the defendant fail to comply with the order of the court, the clerk shall notify the court of the failure for further proceedings. The payment of restitution to any person suffering physical injury or personal loss as a result of such offense, if the person is economically capable of making such restitution, shall be imposed as a condition of probation under TCA 5510-410. I need you to sign that and date it along with your lawyer to indicate that that has been read to you in open court. Count 2, you're found guilty of reckless aggravated assault and sentenced to 12 years in the Tennessee Department of Corrections. That will be suspended to community corrections consecutive to count 1 when you're going to serve that 11 months and 29 days, day for day. And that will be at 100% release eligibility. What that means is that when you're released from jail, you violate one rule of probation one time, and you will go to jail, go to prison for 12 years, and that will be 12 years to serve, not 12 years at 30% or any of that. You'll serve 100%. You understand that? Count 3, you're also ordered to pay court costs on count 2. Count 3, you're found guilty, sentenced to 6 years. That will be suspended to community corrections, and concurrent to count 2, all the pending general sessions court cases were to be dismissed as a part of this agreement, and court costs, as I've said, will be ordered. You get credit from August 28th of 2025 until today. That's the judgment of the court. Thank you. I will say this, Mr. Friels, you're lucky that you're not being charged for vehicular assault, vehicular homicide, or something more serious. Ms. Robertson has made it clear that she wants the court to recognize the seriousness of it, and I do. I think the district attorney has recognized it because a 12-year sentence is nothing to sneeze at. By the same token, as I've indicated to you, for the next 12, 13 years of your life. You're either going to be in jail or you're going to be on intensive probation. And you violate one rule one time, and it will be easy for this court or another court to send you to serve that 12 years. All right, that's the judgment. Thank you. On page 1.
I'm working on a plea sheet for Mr. Albu. It's not ready yet, so if the court can second call that. I don't think
We're
there's
working on
any reason to bring him up. Thank you.
it. Mr. Wainick, interrupt you, I'm sorry. On State versus Tyrone Hogan, you had indicated at one point that you wanted a trial date. Is that correct? Or
We talked about a trial date because we said no to the offer.
do you think, is there any indication that a that a plea can be, I mean, there are some cases you can pretty well determine that it's not going to be able to be settled. Some cases you need some additional time. My question to you is, I can assign a trial date if you determine that it's one that's not going to be able to be settled.
How about we do this? My suggestion would be, let's set a status date. I may need to set a date for him to be brought to the jail if I can't get in to communicate with him, so I can go over things. And that if we can set a short status date instead of a trial date.
So, well, I mean, the next status date for this court is January. You want to try to set a date for your client to be brought down. He's in the Department of Corrections, correct?
He is, and now I know which prison he's at. TDOC had him listed somewhere else.
So
But
do
if
you
we-
want to have him set for the 7th, and then on the 7th, you can enter an order that will have him transported the weekend before so that you have an opportunity to talk to him?
if need be, yes.
And we'll reset Mr. Hogan's status for January 7th. And, yeah, we're going to take him off the trial docket at this point. When did we set the trial?
June 3rd through the 5th. Yeah, he was at one of the prisons that was just
Well-
impossible to get anything from. We don't need to, I can go back and tell him. We don't need, unless y'all want to bring him back. Do I?
Madam Clerk, what we're doing after my meeting with the defense counsel and the state, when I assign a trial date, it is going to be a hard and fast rule. It will go to trial. I will not accept a plea. So I'm giving the lawyers fair notice of that. We've been given permission to settle some cases that were set for trial from here on out. If they request a trial date, it will go to trial, or they'll plead to the indictment and go to sentencing. I'm not accepting pleas in front of a different judge or anything else. No, I've told them that. But this time I really mean it. So. Haven't you ever dealt with your children where that would be the situation? You tell them and tell them and tell them, and finally you say, okay, this is it. I'm serious. I really mean it this time. Well, this is what I'm telling you. So.
Because my daughter watches this. No, my daughter was perfect. We never had any issues.
All right. Who do we have? Anybody?
Can you state your name for the record, please?
Joshua Andrew Garton.
Are you currently on probation?
Yes.
What county is that probation out of?
Benton County.
What county did that probation originate on? What county did the case that you were put on probation come from?
Dixon County.
And it got transferred to Benton County?
Yes.
Is the arrest on these charges why your probation was violated and why you're being held with no bond?
No, I don't think so.
Are you being held on no bond because your probation was violated?
Yes.
On these new charges? The new arrest that you're facing in Dixon County,
Yes.
is that what violated your probation? Prior to the arrest on these new charges, were you ever violated?
No.
Never missed court?
No.
Never failed a drug screen?
No.
No further questions.
Mr. Brooks, you have any question?
Mr. Garden, isn't it true that on or about December 20th of 2022, you were convicted in this very court for soliciting sexual exploitation of a minor, a B felony?
Yes.
Where were you living when you were picked up?
Dixon County.
Okay, what was the address?
318 Martin Luther King Boulevard.
an apartment complex?
Yes.
And said you were currently on probation?
Yes.
Where were you being supervised out of?
Benton County?
Benton County? And what were you on probation for in Benton County?
For the charge of exploitation of a minor?
Okay, so you're still on probation for the conviction I just previously mentioned?
Yes, that's a 6-year.
Okay. But when you were arrested on this VOP, you were living in Dixon?
No, I was living in Camden.
Okay. What was the address that you were living at when you were arrested for this new case that brought you into custody right now?
That was 318. I just moved there actually just 6 months ago, so I can't really answer that because I don't even know the address right now.
Okay.
Yeah.
So you do not recall the address that you were living at the time that you were picked up?
No.
Okay. But that was in Camden?
Yes.
Okay. How long had you been living at that Camden address?
About 6 months, 7.
Would this been reflected on the sex offender registry?
Yes, it's on there.
Is there any other reasons for the current violation of probation that you have open that you stated, that your attorney referred to? Is there any other reasons why that's been alleged that your probation was violated?
Mm.
I didn't think we did. That was news to me, but I'll double check that after this. Mr. Garten, do you have family in the area?
Yes, there's one here right now.
Who is that?
Cherie Carter.
And who is she to you?
That's my mother.
Okay. And where does she reside?
I don't know. She just moved there. I don't know the address.
Okay. But she resides in Dixon County?
No, she's like very close to me, like 15 minutes.
Okay, so in Camden?
Yeah.
Okay. Is that the only family member you have in the area?
My dad,
Okay, where does he reside?
Van Leer.
All right, are you close to your dad?
Yes.
You still talk with him?
Yes.
But he's not here today?
No.
Okay. Do you work?
No.
Okay. When's the last time you had a job?
I'm on Social Security. I don't have a job.
Mr. Garten, isn't it true that when you were initially picked up, that you instructed family and/or friends to not attempt to bond you out because you wanted to accrue time in jail to build up for a civil action in the future?
Yes.
Now you're here telling the court that you cannot bond out on the current bond?
I didn't know I even had a bond. I was told when I was picked up that I had a bond, and then when I got there, they said I didn't have a bond.
Can you state your name for the record?
Cherie Carter.
You scoot up to that microphone and speak loudly.
Cherie Carter.
And where do you live, Ms. Carter?
I live in Camden.
Is that where Josh lived before he was jailed on this matter?
Yes, I am living at his house. He just wasn't aware of that.
What is your current address?
8045,
How long have you lived there? I'm sorry, 8045.
yeah, Highway 69A, Big
What's it?
Sandy,
How long have you lived there?
since end of June.
Do you rent or own?
I own that house.
Does anyone live with you?
Right now, it's my husband,
Your husband
my
and,
husband and my daughter.
and this is where Josh would go to if he was granted bond in this matter?
Yes, it's his house.
Are you employed?
I am not employed. I'm disabled.
How much does disability pay a month?
$967.
Do you drive?
I do.
If you cannot get Josh to court, is there anyone else in the household who could provide transportation?
Oh, yes, my husband.
So you both have transportation options?
Yes, we do. We both do.
Has Josh ever been diagnosed with any mental disorders?
Josh has been diagnosed with autism since he was 10 years old. He's Asperger's.
Can he work?
He cannot work.
Can he drive?
He can drive.
Has he driven himself to court before?
Yes, he's never missed anything.
He's never missed court.
Never. He's been on time
General sessions and any court date he's never missed.
for anything.
Would you
He's
describe
pretty-
him as timely, early?
Early. He's usually early, though.
Have you made a bond for him before?
I have never made a bond for him.
Do you have any reason to believe that Josh has any ability or intent to miss court should he be granted a bond?
Absolutely not.
Nothing further, Your Honor.
Mr. Brooks, you may cross-examine.
Morning, ma'am.
Good morning.
Do you work?
I do not.
You do not, so you're at home primarily most of the time?
I'm at home all the time.
Okay. And that's where, if Josh were to, your son were to bond out, that's where he would stay?
Yes.
Was that where he was staying when he was arrested?
Yes, that's where he was staying when he was arrested. He gets confused about things, but
Okay.
yeah.
So he was staying with you when he got arrested in Camden?
No. I moved up from Florida. I sold my house, used all the proceeds to hire a lawyer. I just come up here from Florida so I can be there for him.
All right. So he was not living with you when he got arrested?
No, he was by himself.
Okay. Is there any other family in Camden?
No, not in Campton. He's very close to the neighbor, him and his wife, and he has his dad and his stepmom's over there.
Was he dating anybody at the time?
I wouldn't say dating, no.
Okay. Do you have grandchildren?
Do I have grandchildren? No.
No. Nieces or nephews, young nieces or nephews?
I don't have any family here.
Okay. Any children visit your residence?
No,
Okay. You realize that he's on the sex offender registry?
I do, but I'm not from here, so.
Okay, but you understand that there's certain restrictions? that he-
Absolutely.
Okay.
I'm here to support him, so.
You realize what he's charged with?
I do.
Okay. You realize those are very serious allegations?
I do realize he's innocent to proven guilty, but I also realize
But
that.
you understand that he's looking at a very big exposure as far as what he's looking at if he's convicted at a trial?
I'm ready to be there for him at every step.
You realize he's been previously convicted of possessing child porn?
Yes, I do.
That's all I have, Judge.
Redirect.
So given the seriousness of the charges and the conditions that would be placed on him, should he be granted bond, do you have any reason to believe he would violate any of those?
Oh, absolutely not.
And you would be able to understand and help him understand any of the conditions?
I've always tried to help him understand everything the best I can.
Yes, ma'am. Thank you.
Brooks.
Did you say you have a daughter that lives with you?
And she's 18.
She's 18? Okay, that's all I have, Judge.
All right, thank you, ma'am. You may step down. Have a seat in the courtroom if you'd like.
Thank you.
You may call your next witness. They have any witnesses they wish to call?
Can you please state your name for the record?
Katrina Pulley,
And where are you employed?
Dixon Police Department.
And what is your position?
I'm a detective.
All right. Do you have a you have a case involving a Joshua Garton?
I do.
What was your involvement in that case?
I received a DCS referral in reference to possible child sex abuse, and investigated that referral.
Right? And you're aware of the allegations made in that, and you presented it to the grand jury, correct?
Correct.
Okay. What did you do to, what were you able to do to corroborate the allegations in this case?
We first began with a forensic interview with the victim, BB, who stated that she was approximately 7 years old, which would have been around 2018, 2019. She stated in the forensic interview, as well as an interview afterwards with she and I, that the defendant, Mr. Garton, penetrated her 10 times with his, well, she called it that thing. That thing is a penis, and 5 times with his fingers.
Okay. Did you do any follow-up once you got these initial sexual abuse allegations? Like, were you able to corroborate any of these allegations?
I was. So when I met with BB, I was able to provide her of some photographs from inside of Mr. Garton's residence at the time that this would have occurred. BB was able to identify each photo that I showed her. One of the photos that I showed her was a picture of a bed, and I asked BB if she could tell me what that was, and BB stated that that was Josh's bedroom and his bed. I asked her how she knew that it was his bed, and she told me because that's where all of that happened.
Under what circumstances was this child placed in respect to the defendant? How was she around him?
She was around him. BB's mother and girlfriend of Mr. Garton's at the time were best friends, best friends, and neither one of them I know BB's mom does not drive. Not for sure if the other female drove, Josh's girlfriend at the time. I don't know if she drove or not, but they would bring BB over to Josh or to the girlfriend's house, and then the girlfriend and BB's mother would walk to the store, convenience store, Walmart, to get necessities that they were going to get, and would leave BB there with Josh to babysit.
Okay. Now, you stated the victim BB was able to identify pictures from the defendant's residence.
Correct.
Had you had any interactions with the defendant and that residence prior to these allegations coming forward?
Yes, in 2019, I investigated the exploitation that he pled guilty to. And
Right. Now, he admitted that he was found guilty. He pled guilty to being in possession of child pornography, correct?
correct.
Right. Aside from the timing of when he was in possession of it in relation to these allegations, what else is troubling that you saw from what was found?
So one of the preferences as far as with the child pornography case was with children under the age, I would say 10-ish. And she fit the description of some of the pornography pictures that was obtained by Mr. Garton back in 2019 case.
Now, these disclosures came years after these alleged events, correct?
Correct.
And what was the reason given for that?
So I did ask BB that, our victim, and she told me that Josh said that he would kill her or kill her family if she ever told anybody.
That's all I have, Judge.
You may cross-examine, Mr. Yeager.
Ma'am, you said that she detailed or claimed 15 times Mr. Garten engaged in inappropriate sexual activity with her.
Correct.
How did she arrive at this number?
So I asked her that. Not only did she say that in the forensic interview, she also said it later on with a one-on-one with just she and I.
So she was able to name specific dates when these happened?
She did not name dates. She
So-
just said it was 15 times during both during the conversation that she had during the forensic interview and then the conversation that she had afterwards. But I did ask her how she knew it was 15 times, and she advised me that it was because it happened to her and she remembers each time.
But no specific dates.
Other than it was around, she told me it was right before Josh went to jail in 2019.
Anything to corroborate this number other than the word of an 8-year-old?
Correct.
Okay. When you were having this forensic interview, did you question any other witnesses that BB might have mentioned?
I did.
Without going into names, could you describe those two witnesses?
As far as their age, or what are you wanting
Yeah,
me to?
age, sex.
Okay, so I'd have to look at my file to be specific, but one was a male, and I know they were brother, sister. I believe at the time of the incident, so in 2019, I'm thinking we were looking at maybe 5 and 8, 5 and 9, and I may be off on that. I'd have to look, but I know the female was younger.
And what did the male testify to you?
The male stated that nothing has happened.
Nothing had happened.
Correct.
What did the female state to you?
Same thing.
So the only two other witnesses.
Well, they didn't state it to me. They stated it in a forensic interview at the CAC.
So there was nothing to support her allegations that these two other children were engaged in any inappropriate activity with Mr. Garten.
Correct.
And the only way we got to this 15 number is that this child said it.
Correct.
We have not corroborated it in any way. There's no evidence to support that,
Correct.
other than the word of an 8-year-old.
Correct.
No further questions, Your Honor.
Redirect, Mr. Brooks. Thank you, Detective.
Thank you.
May step down.
Your Honor, I believe that Mr. Garten checks just about every statutory box that you will consider when considering whether to grant a bond in this matter. He has roots near to the community. He lives with several immediate family members close to this court. He's able to drive himself to court, as he has done in every previous court appearance. But even if he couldn't, there are multiple members of the household who could get him here. His diagnosis means that he is unable to work and keeps his flight risk to about 0. There are no factors that would suggest that he's at any risk of being a willful failure to appear in this court. I would finish by urging Your Honor not to put too much weight on the nature and number of these charges. As I think the detective just testified, there's really no base for these. While the severity and the sheer number of charges that he's facing is serious, we would say that there's a very questionable foundation for both the nature of the charges and the number. I'm not sure we've heard anything today that would dispute that. That's what I would submit to Your Honor.
Mr. Brooks?
Looking at the bond factors, the state would submit that they do not favor the defendant. He has very extremely weak ties to the community. He's only able to list 2 people that even live within a throwing rocks distance between our county. His mother admitted to moving from Florida and has only been in Camden for several months and is just here to support her son. The defendant's own admission, he'd only lived at that Camden location for 6 months and could not even list the address that he was living at. He does not work. The charges that he's facing are extremely severe, and he is looking at decades in prison if found guilty. The state has submitted enough proof today to show that there's more than sufficient foundation for these charges. There are some troubling things in this case that corroborate these allegations, Judge, as the court can see. The state would submit that the bond as set right now is more than sufficient.
court file reflects that there is a bond in place that was set at the time the original warrant was issued of $200,000 with a condition to have no contact, direct or indirect, with the victim or the victim's family, and to have a GPS monitor if he makes that bond. I do not, at this point, have a warrant for violation of his probation that he was on, but clearly, I'm assuming one of those is going to come forward because of these new charges, if no other reason. The court has considered the testimony of the witnesses and the facts in this case and makes the following findings. The defendant's length of residence in the community, he does have a lengthy residence in the community, and I'm referring to those factors set forth in the Tennessee Code annotated 4011-118. He does have a lengthy residence in the community, albeit for the last 6 months prior to his arrest, he was living in Camden, Tennessee, which is not a part of this community. Not sure if that was authorized by the probation department or not, but I'm assuming he may have gotten permission to relocate. The defendant's employment status and history of financial condition provided that the defendant's ability to pay shall not be considered. He is not employed and does not have any means of employment other than Social Security disability. Family ties and relationships, his mother testified on his behalf, and that is a factor. His reputation, character, and mental condition, clearly he is, and I'll couple that with the next one, which is his prior criminal record of appearance at court proceedings, and a record of flight to avoid prosecution. He has a prior conviction for solicitation of a minor. He's on probation for 6 years. And as a result of that, that is a factor that the court can consider. The nature of the offense and apparent probability of the conviction and the likely sentence. Again, these are all Class A felonies. This counts 1 through 15 of this indictment is that he's charged with rape of a child. And that's 15 different counts of that. I understand the argument that how would a child of that age know, but, and not to place too much weight on the only evidence being the testimony of a child, but the testimony of victims of sexual abuse is often the only evidence that there is to substantiate it. And that's up to the jury to make that decision. But the continuous sexual abuse of a child is the 16th count of that indictment. And obviously that's a relatively new charge that carries with it a more enhanced punishment. But if he is convicted, he will be serving, as Mr. Brooks put, decades in prison. And he's already on probation for a sexual offense. As a result of that, the court finds that that is a factor that does weigh on the court in setting or determining the correct amount of the bond. The identity of responsible members of the community who would vouch for him, his mother is the only one who would vouch for him. Other factors indicating his ties to the community are bearing on the risk of the willful failure to appear. I don't really see any, but it does indicate to me that the court at some point has to consider the possibility of protecting the public at large from someone who has an inclination to commit sexual offenses. He's found guilty and on probation of a sexual offense and now has 16 counts of sexually abusing a child. And the court finds that the bond of $200,000 is sufficient, and that I do not find there to be a basis for the reduction of that bond, and that bond will remain in that amount. Those conditions that were placed at the time of the issuance of that will remain as well if he were to make that bond. In addition, I don't know whether the probation department may determine they don't have grounds to issue a revocation, but if they do, then a violation of probation warrant will have to be considered by the judge who receives it and determine the bond in that case. We don't have one right now. So that is the ruling. Motion for a reduction of this bond is denied.